Good evening, ladies and gentlemen. Very warm welcome to UCL Laws. My name is Pete Eckhout. I'm Dean of the Faculty, and it's a great pleasure to welcome you to this inaugural lecture by Professor Paul Davies. The inaugural lecture is a kind of rite of passage. It's an opportunity for a new professor to inform a wider audience about their field of expertise and about their research program. And I'm particularly delighted that we have Paul here presenting his inaugural lecture. Paul has come to UCL fairly recently, so the inaugural lecture comes relatively early. It even makes me worried that he may have intentions to leave, but I'm sure that's not the case. So very much to be commended to do it early, speaking to some other colleagues here. And he has really seamlessly sort of become part of our operations here at UCL, and I'm really looking forward to his lecture. Now, my main role tonight is actually not to introduce Paul, but to introduce our chair for this evening, Lord Sales. And it's, of course, also an opportunity for us at Laws to, in person, congratulate Lord Sales with his elevation to the Supreme Court, which took office this month. Lord Sales was educated at Royal Grammar School in Guildford before reading law at both Churchill College, Cambridge, and Worcester College, Oxford. He was called to the Bar of England and Wales at Lincoln's Inn in 1985. Was appointed first Treasury Junior Counsel 1997, an assistant recorder from 1999 to 2001, recorder from 2001 to 2008, and Deputy High Court Judge from 2004 to 2008. Lord Sales became Queen's Counsel in 2006 and continued to act in the renamed post of First Treasury Counsel Common Law until his appointment to the High Court, Chancery Division in 2008. He was a member of the Competition Appeal Tribunal between 2008 and 2015 and Vice President of the Investigatory Powers Tribunal between 2014 and 2015. Between 2009 and 2014, Lord Sales served as Deputy Chair of the Boundary Commission for England, and he was appointed as Lord Justice of Appeal in 2014. He's a very long-standing friend of the faculty. It's always a huge pleasure to see him, and extremely grateful that you took time out of your, I'm sure, very busy schedule to chair this evening lecture. Over to you.
Thank you. Good evening. I have to say I'm still at the stage when someone says Lord Sales, I'm looking around to see, well, who is this person? But thank you very much for that generous introduction of me. My turn now to introduce Paul and his lecture. Introducing a lecture is a welcome task for a judge. They get to speak, everyone has to listen, but they don't have to think or say anything intelligent. They are there to listen to the pearls of wisdom from the lecturer, and so it is this evening. It's an especially welcome task for me to introduce Paul Davies' inaugural lecture as Professor at UCL, because I hold him in such high regard. It was at a book launch 5 years ago, in fact, for Ben Macfarlane's book on proprietary estoppel, that a scruffy individual approached me and asked the cryptic question whether I still believed in accessory liability in civil law. The question was not entirely bizarre. I had written a short article on that topic 15 years before. The scruffy individual looked relieved when I said I still did hold to my possibly heretical belief in accessory liability. He confided in me that he was writing a book on that very subject. The scruffy individual was, of course, Paul. Little did I realise what a compelling and thorough work of legal scholarship his book, Accessory Liability, would be. It took the debate about this important topic to a whole new level. As I wrote in the foreword for his book, this is a work of formidable scholarship. It is 150 years overdue. It was the winner of the Inner Temple Book Prize in 2018 and the joint second prize winner of the 2015 Society of Legal Scholars Peter Burke's Book Prize for Outstanding Legal Scholarship. I came to learn that Paul is an incisive and deep thinker across the whole of private commercial law. editing leading works in contract and trusts, and writing articles at what seems to me to be a furious pace. He has recently been asked to join the editorial team for Chitty on Contracts, taking on the chapters by the great Gunter Treichel. There are no higher accolades in the field. His work has been cited by appellate courts in the United Kingdom, Australia, Canada, New Zealand, and Singapore. Paul started as an undergraduate at Cambridge studying Japanese of all subjects. He gained the top marks in the university in Part 1 in that subject before switching to law. Sadly, he now rates his Japanese language skills as only intermediate, no doubt as a result of his dedication to his study of law. He proceeded to take Stars First in law in Part 1B and Part 2, and then became a fellow in law at Gonville and Caius College in Cambridge. He also worked in the property and trust law team at the Law Commission. Then came a fellowship at St Catherine's College, Oxford. He was appointed to the chair in commercial law here at UCL in September 2017. UCL is fortunate indeed to be able to add Paul to its impressive roster of leading private law specialists. Paul has even spruced himself up for his inaugural lecture on the topic of bad bargains. Please join me in welcoming this evening's lecturer, Professor Paul Davies.
Thank you very much, Philip, and thank you all for coming. I think that all my lectures at UCL should have that sort of introduction and that sort of welcome. It's a real privilege to be able to give my inaugural lecture this evening, and I'm very pleased that so many of you have made the effort to come along when I know how busy everybody is. Giving an inaugural lecture is a chance to think about what's led me to UCL. And it's interesting, it comes at a time that the 10-year challenge has gone viral on social media. So for those who don't know, the idea is that you post a picture of yourself now and a picture of yourself 10 years ago, and you think about what's changed. And when I look at photos of myself 10 years ago, I look quite different. I look younger. I had more hair. I didn't have a lot of hair, but I had more hair. And I didn't look quite as tired before I had children. But then when you think about where I was 10 years before starting at UCL, I was just about to start as a research assistant at the Law Commission. And I hadn't written anything, I hadn't published anything, and at the time I had no intention to be an academic at all. So a huge amount for me professionally has changed in 10 years. And I've had a lot of luck to get here, but also a huge amount of support and help. And it's very good, and I'm very touched that so many people who've helped me are here tonight. So it would be very boring to thank everybody individually, but I would like to start with some thank yous. I'd like to thank Philip for chairing the lecture, for his generous introduction, even if some of you don't know how scruffy I am on a normal basis, and for taking such an interest in my work generally. It's really appreciated. And what Philip says about my career his career has been very impressive too. So since we met 5 years ago, at the time he was a first instance judge, and as Pete says, he's now just starting the Supreme Court. And his rise has been very quick and great to see, and I'm sure he'll be an influential justice for some time to come. I'd also quickly like to thank my family for their support and for coming tonight, when at one point it didn't look like they would. When our events manager told me, or when I told them that our events manager had said it was usual to invite your parents to an inaugural lecture, they both initially reacted with surprise. And the first thing they did was to ask whether it would be recorded. And you can see that this is being recorded. And then they had to do the calculation that all students do about whether it's worth trekking into central London in January. And you can just catch it up later. But then when Dad checked that this was on a Thursday and it didn't clash with Mansfield Town playing at home, they came round to the idea. And it's very good to see them both here tonight and to thank them publicly. And to thank my wife, Maureen, for her support as well. Maureen was perhaps even less excited at the idea of sitting through her first ever law lecture, but she's patiently supported us as I've carted us around from London to Cambridge to Oxford and now back to London, which wasn't at all our plan when she first moved to England 12 years ago. And I'd also finally like to thank our children, Emma and Luca, for making sure that I didn't become too distracted by bad bargains over the past few weeks. And I suspect that when this recording does go up on YouTube, they might, with a bit of patience, watch up to about here before asking to watch Baby Shark again for the millionth time. Anyway, inaugural lectures at UCL are part of the Current Legal Problems series. And as I've spent much of January procrastinating and putting off preparing this lecture, I've looked back over inaugural lectures that have been given here and published in Current Legal Problems over the past 100 years or so. And at one point, it really looked like a new professor could get away with reading something in the Times on a Monday and then coming along on a Tuesday with some thoughts about that case, which at one point seemed a very attractive approach for me to adopt. But sadly, the demands placed on academics have changed somewhat. But in paying respect to my predecessors, in this talk tonight, I will try to focus on some of the more interesting recent cases that are relevant to my work on bad bargains. But this is quite a difficult lecture to give. An inaugural lecture is quite a difficult lecture to give because this is a very good example of what we might call a mixed ability group, where all false modesty aside, there are some people who could give the lecture much better than me in this room. There are some people who are lawyers but not contract lawyers, and then there are some people who aren't lawyers at all. So I suspect I'll do what I tend to do in such situations and speak so that no one leaves the room very happy. But for those who are interested, there is a written version of this paper, which will hopefully be up on the Current Legal Problems website in due course. And when thinking about a current legal problem to talk about, I think everyone's mind first goes to Brexit. And at one point, I did think about giving a talk on Brexit and contract law. But Philip just said to me before that he turns off the radio now when he hears Brexit come on. So I'm pleased that I didn't do that. And instead, I'm going to talk about bad bargains more generally. And of course, it's not entirely divorced from Brexit because the effect of Brexit will be that some contracts will be bad bargains for one party or another. But the talk is broader. And what I want to do is to first say what I mean by bad bargains and why we hold parties to bad bargains. Then say something about how we determine what the bargain is, and then how parties might escape from contracts through misrepresentation or duress. And then finally, I'll try to say something quickly about frustration. But let me start by giving the facts of a recent decision of the Supreme Court of Canada in Churchill Falls and Hydro-Quebec, which was handed down a few months ago. So the case concerns the civil law of Quebec, so it's not a common law case. But I think the issues raised and the facts of the case are useful to think about in the context of bad bargains. So in 1969, so 50 years ago, Hydro-Quebec agreed to purchase electricity from Churchill Falls for a fixed price over a 65-year period. But since the contract was entered into, there have been significant changes in the electricity market in Canada. And most notably, electricity is no longer viewed exclusively as a public good, but rather as a source of profits. And this has meant that electricity prices have soared. And that shift, the soaring of prices, means that this contract has become extremely advantageous for Hydro-Quebec, which is able to purchase electricity at the low prices fixed back in 1969. And conversely, Churchill Falls finds itself stuck with what now looks like it's a bad deal. And so Churchill Falls bring this claim, and it tries to argue various points, including that this was a relational contract and that implied obligations of good faith mean that the contract price should be renegotiated. And these arguments were rejected by a majority of the Supreme Court of Canada. And I think that a similar result should be reached in this jurisdiction too. And indeed, to some extent, it's a bit surprising that this case gets all the way up to the Supreme Court and that there was a dissenting judgment saying that Hydro-Quebec was under an obligation to renegotiate the price. Because that looks to me like undue interference from the courts in the bargain that was made by the parties. And essentially, I think it's important that Churchill Falls should not be able to escape this sort of bad bargain, and that by agreeing to such a long contract with fixed price, it knew what it was doing, and it knew that there was a risk that market prices would move and it might become a bad deal. I've just realised I haven't turned the microphone on. All right, done that now. So it would have been possible to include break clauses or price review clauses within the contract, but the parties hadn't done that. That wasn't agreed. And it shouldn't be for the court to intervene later on and improve the bargain that's been made. And even on the facts of Hydro-Quebec and Churchill Falls, it's not entirely obvious when you take everything into account that it really was such a bad or such a terrible bargain for Churchill Falls, and the court might find it difficult to conclude that it was. And that's because by agreeing to this contract back in 1969, Churchill Falls had a guaranteed purchaser of electricity for a long period of time, which is obviously an advantage in itself. And at the beginning of the contract, Hydro-Quebec helped to pay for this hydroelectric dam that was owned by Churchill Falls. Whereas if they hadn't done this, they might have constructed their own dam. And these were significant advantages which were taken seriously by Churchill Falls. And so basically I think they freely made a commercial decision which they shouldn't be able to walk away from. And it's not for the courts to interfere with the allocation of risk that's deliberately made by the parties under their contracts, whether that be through interpretation, principles of good faith, or whatever. But perhaps I should say that I'm focused here on commercial contracts, so I'm not dealing with consumer contracts or employment contracts, or those sorts of contracts where they might operate differently. There might be other policy reasons for them to operate differently. But on contracts typically made between commercial actors. And I think that's important because English contract law is, to a very large extent, outward-looking. So English contract law is trying to speak to a range of international parties who choose English law to govern their agreements, where they otherwise have little or no connection with this jurisdiction. And that's different from the civil law of Quebec, or even from French law or German law, which is less international in its outlook. And I think it's worth thinking about, I'm a professor of commercial law in London, it's worth thinking about why English commercial law is so popular, and maybe particularly after Brexit, or given the uncertainties created by Brexit, when other legal systems are making a play for a larger share of the legal market, it's important to be clear about why English contract law should still continue to be popular. And I think that business people choose English law to govern their agreements because it is certain, it favours certainty, it affords full respect to the principle of party autonomy, and it holds people to their bargains. Even if those bargains turn out to be a bad bargain, it holds parties to their bargain. Because freedom of contract is a key principle of English commercial law. And I think that judges generally just want to give effect to contracts freely entered into, rather than take any sort of active role and try to improve them. And this helps to generate trust in the system of contract law. Admittedly, it's often only artificial trust, but it's trust that encourages parties to contract, knowing that their agreements will be enforced. And it's helpful as we go through the material in this lecture to remember that courts won't assess the adequacy of consideration and that contracts can be unfair. So, as Lord Sumption has recently said, commercial parties can be most unfair and entirely unreasonable if they can get away with it. Right? It takes two parties to enter into the contract. If they can get away with being unfair, then the law won't intervene. And this reflects the traditional adversarial view of contracting, where each party sets out to achieve the best deal for itself at the expense of the other side. And I confess that I take quite a hardline approach in this area, that it's important that commercial parties take responsibility for their agreements. And the courts should not rescue parties from what might be called their own commercial fecklessness. So courts should not make a bargain reasonable where the parties themselves have not acted reasonably. And commercial actors should take care when entering into contracts, and they should give careful thought to the written documents that they sign. And a powerful way to emphasise the importance of this is by making it difficult for parties to escape the consequences of the contracts they have entered into. Now, of course, there are exceptions to this, particularly when a party has been lied to or unlawfully coerced into entering the contract. And I'll talk about those sorts of cases in a bit. But it's important that A commercial party should not be able to escape a contract just because it regrets entering into the contract. So if a party unilaterally makes a mistake, taken by itself, that's not enough for the courts to intervene. And again, I think that's a good message to send out, because people need to take responsibility for what they do. And as I say, I'm conscious that's quite a hard line to take, that our head of school came into my office just before I left for this lecture and said she disagreed totally with the thesis that I was going to argue. And as I've talked about this a bit with friends, it's been suggested to me that one of the reasons I might be influenced or might take such a hard approach is because I'm a chess player. And I think the idea is that chess is a game where you play entirely by yourself, and it's inevitable you'll make mistakes, and the consequences can be quite drastic. It's quite brutal to play a nice game of chess, make a bad mistake at the end, and you are going to lose. But at that point, the arbiter or the referee won't step in and help you. You have to suffer the consequences. And there's a great grandmaster, Savely Tartakova, who said that his favourite position in chess was the opening position, because all the mistakes are out there at the board just waiting to be made. Right? It's inevitable that you're going to make mistakes. And it's the same when you're negotiating for contracts. Right? Mistakes are going to be made, but it's not for the courts, as the judge or as the arbiter, to step in and help you. So before looking at some of the more controversial cases, I'd like to say something very briefly about what a bad bargain is. And the term hasn't been clearly defined before, and both words, bad and bargain, are to some extent ambiguous. So a bargain is sometimes used to refer to something that's just cheaper than it normally is. So clothes that you might buy in the shops in the January sales that are cheaper than normal might be described as a bargain. But in a more legal sense, bargain is synonymous with contract. And that might explain why you need consideration to form a valid contract. So you might think of consideration as a sort of price tag on a promise, and the need for consideration is consistent with contracts being bargains. Now, there are some contracts where you don't need consideration. They might be made in a deed. But for the purposes of this evening, I want to include all contracts that turn out to be bad for one party. And the composite term bad bargain is perhaps most commonly used in the sense of losing contracts. So in the Mamola Challenger, Mr. Justice Tier said that a contract would be a bad bargain where the expenditure exceeds the gross profits that you're likely to make. So where the claimant, for example, has already incurred expenses or expenditure which are more than the gross profits it's likely to receive under the contract. And sometimes this could be deliberate, it could be a loss leader, but often parties stuck with losing contracts will try to escape it somehow. But I think we should talk about bad bargains in a broader sense than just losing contracts. So contracts may be bad in the sense that they are unfavourable when compared to other contracts that could have been entered into. So in other words, there's an opportunity cost of entering into this contract, and that opportunity cost renders it bad. And parties might regret entering into such agreements. And again, parties may seek to escape those sorts of contracts entirely, but since those contracts might be profitable, even if not as profitable as had been hoped, the parties might try to interpret the contract or imply terms or rectify the written terms in a way that makes the contract more profitable. And I think the Hydro-Quebec case is a good example of that, where the contract was profitable, but just not as profitable as they hoped. And there were lots of ways that a bargain might be bad. So some bargains might be bad from the outset. So one party might not have been able to negotiate a better deal, for example. But often a bargain will become bad due to events that occur after entering into the contract. And that may be due to the conduct of the other party, who might perform the work slowly or badly, for example. Or a contract might become a bad bargain because of one party's own conduct, such as not acting as promptly as it should have done, then renders the contract disadvantageous for itself. And for those who know the case, I think the recent decision of the Supreme Court in Wood and Capita could be an example of that. And then there's another category of bad bargains where a contract might be bad because it's illegal, which involves consideration of the difficult case of Patel and Mercer, but I won't have time to talk about that this evening. But when you think that there are lots of different ways that a bargain might be a bad bargain, that's then helpful in thinking about what sort of avenues a party lumbered with a bad deal might wish to pursue. And the approach of the courts might differ according to the reasons why the contract has turned sour. And I clearly can't explore all the issues in the time given tonight, but in general, I think it's right for the law to take quite a tough line and say that parties who made a bad bargain are stuck with it. And this largely corresponds with the decisions from the courts, but as ever, there are some difficulties that I'll try to flag up. But first, I want to say something briefly about how we determine whether a bargain is bad or not, which invariably involves questions of interpretation and potentially implication and rectification. Because until these issues are resolved, the bargain might end up being good or bad, depending on the approach taken by the courts to determining the meaning of the contract. And taking a signed written contract at face value, or in accordance with its plain meaning, to use a controversial term, the terms might well suggest that one of the parties has made a bad bargain, but that party might argue that background factors, or the matrix within which the contract was concluded, should be taken account and the contract interpreted in a way that means that it hasn't made a bad bargain at all. And this is an area of law which is incredibly important, but has also given rise to a huge amount of litigation and commentary and disagreement about the correct approach to take. And some of that has been quite personal and hostile. And I've written on this topic before, but it seems to me worth saying again that despite the Supreme Court's protestations to the contrary in Wood and Capita, that there has been a shift in approach since Lord Hoffman retired from the House of Lords, and that there's now a greater emphasis on the text, on the language deliberately chosen by the parties, rather than the context. And I think this must be right. I think it would be helpful if it was spelled out more clearly by the appellate courts. But to illustrate the point, it's useful to think about the facts of what's now the leading case, Arnold and Britton. And this case involved the interpretation of a service charge clause in leases of holiday chalets. And the clause provided that the tenants had to pay a service charge of £90, which would increase by 10% every year. And the effect of compound interest meant that this service charge would increase exponentially. And so 25 years later, it would be just over £500,000. But despite that, the majority of the Supreme Court held that this strict interpretation of the contract should be enforced. And Lord Neuberger said that a court should be very slow to reject the natural meaning of a provision simply because it appears to be a very imprudent term for one of the parties to have agreed. Because the purpose of interpretation is to identify what the parties have agreed, not what the court thinks they should have agreed. And it's not a function of the court to relieve a party from the consequences of his imprudence or poor advice. So the court shouldn't rewrite the contract to try to help one of the parties. And I think that that's right. I think that it might be that the parties were just not able to negotiate a better deal, either because the other side was driving a very hard bargain or because they themselves were incompetent. But it doesn't really matter, because the best objective evidence of the parties' intentions and what the parties agreed is the language of the contract itself. And we should be very slow to depart from that language where it is clear and not nonsensical. But it's revealing that there was also a dissent in Arnold and Britton. So Lord Carnwath dissented, and he took an approach that much more closely resembles that favoured by Lord Hoffman, where Lord Carnwath was prepared to use background factors to reach a different interpretation of the clause, because he said the majority's interpretation didn't make any commercial sense. And I say this conscious that there are judges here tonight, but I think that judges are often not the best arbiters of what constitutes commercial sense. And there's actually a great line by Alan Ward in the Court of Appeal in a case called Oceanbrook, where Lord Justice Ward was clearly pretty exasperated with the House of Lords and Supreme Court overturning pretty straightforward interpretations of contracts. We said that the higher you go in the judiciary, the less the essential oxygen of common sense. With this idea that appellate judges should be careful about rewriting agreements on the basis that it doesn't correspond with common sense. And the approach that Lord Neuberger adopts in Arden Britain, I think, should be followed, that it better respects the autonomy of the parties to choose the particular language in a contractual document, and that should be given effect. So in Arnold and Britain, the parties could have included a break clause, or they could have included a price variation clause, but they didn't. And so it's similar in that way to Hydro-Quebec case, where they could have included a break clause, but they didn't. And where that clause hasn't been agreed, the court shouldn't strain to improve their deal on the basis of commercial reasonableness, perhaps especially if the parties haven't acted in a commercially reasonable manner themselves. Anyway, I discuss this issue in more detail in the written paper, as well as the problems of unforeseen and unforeseeable events. But I think that there are still, unfortunately, cases where the courts are too willing to depart from the natural meaning of the party's language on the loose basis of commercial sense. And I think that's inconsistent with the thrust of Lord Neuberger's speech in Arden Britain, and that it should be stamped out. Okay, so I want to move on now to situations where the language is unambiguous and clearly bad, but one party wants to rescind the contract or escape the contract on the basis that it was induced by misrepresentation or by duress. And these are sort of linked because lies and coercion might undermine the important principle of freedom of contract, that a party's consent might not be fairly given if it was only given due to misrepresentation or duress. And I really want to focus on the remedy of rescission. And a good case to examine on misrepresentation is Zurich Insurance and Hayward, a decision of the Supreme Court from a couple of years ago, where Mr. Hayward injured his back in a work accident, and his employer admitted liability, but Mr. Hayward then overstated his injuries, then exaggerated the claim, and he sought a large damages award of over £400,000. And in the proceedings that followed, the employer's insurer, Zurich Insurance, correctly believed that Hayward was exaggerating the consequences of the accident. So in particular, Zurich Insurance obtained a video of Mr. Hayward, which showed Mr. Hayward engaged in heavy lifting, which was plainly inconsistent with his claim about his injuries. And so Zurich Insurance didn't believe that Hayward was telling the truth. So they weren't taken in by the lies. But regardless of that, Zurich Insurance decided to settle the claim for about £135,000. And then sometime later, Mr. Hayward's neighbours, who obviously didn't like him very much, came forward with new evidence and told the insurer that Hayward had lied deliberately about the value of his claim, which in reality was only about £15,000. So you have these neighbours who've basically snitched on Mr. Hayward. But this new information encouraged the insurer to reopen the case. And the insurer wanted to sue Hayward for deceit, damages for deceit, but it couldn't do that because that claim was compromised under the settlement agreement. So instead it brought a new claim, arguing the settlement agreement could be set aside for misrepresentation. And Mr. Hayward argued that it couldn't be rescinded because Zurich Insurance had never believed Mr. Hayward's exaggerations. I think it's important to note here that at first instance, the trial judge had found, as a matter of fact, that Zurich did not believe Hayward's representations when entering into this agreement. So Zurich was not taken in by the misrepresentation. And Mr. Hayward's misrepresentations did not induce a mistake in Zurich. And saying it like that, I think that means that the claim of misrepresentation should fail, that misrepresentation should really be based upon a claimant's mistaken belief that has been induced by the defendant's misrepresentation. Because in those circumstances, the claimant's decision to enter into the contract was impaired. But here Zurich entered into this settlement agreement with its eyes wide open, well aware of the risks that it was taking. It was concerned that a court might believe the lies told by Hayward, but then it made a commercial decision to settle the case. And as a result, the Court of Appeal held the agreement could not be set aside and stressed the finality of settlement contracts. And I think that decision was entirely orthodox. And I see Lord Briggs nodding along. Lord Justice Briggs gave one of the judgments in this case in the Court of Appeal. I think that the decision of the Court of Appeal was entirely orthodox and consistent with the idea that a person should not be able to walk away from a bargain that has turned bad, that was freely entered into but has turned bad. But the Supreme Court said it didn't matter whether or not the claimant believed the misrepresentation, and that rescission could still be granted if the misrepresentation simply influenced the claimant's decision to enter into the contract in some way. And on the facts of Zurich, Hayward's misrepresentation did have some influence on Zurich's decision because Zurich thought that those lies might be believed. Now, the vast majority of the academic commentary seems very happy with this decision of the Supreme Court, but I think it's problematic. And I think it's problematic because it's inconsistent with the traditional explanations of misrepresentation based on induced mistake. And it undermines the finality of settlement agreements by allowing Zurich to escape a bad bargain it consciously entered into. Of course, it's a difficult case on the merits because Mr. Hayward is a fraudster, and as a general rule, it's good to clobber fraudsters. But there might be other ways you can clobber fraudsters. The problem with the Supreme Court decision is that I think it distorts the law of misrepresentation in contracts. And that would be particularly problematic if it applies to misrepresentation more generally, because you can rescind a contract for non-fraudulent or innocent misrepresentations as well. And it would expand the scope of misrepresentation and rescission in an unfortunate way if you didn't need to show that a party believed the truth of an innocent misrepresentation. So at the very least, Zurich, I think, should be limited to the context of fraud. But even then, I think that parties shouldn't be able to wait and see whether or not the bargain made is a good one. So once Zurich knew that Hayward was lying, it should have had to elect once and for all whether to settle or whether to pursue the claim against Hayward. And because it's settled, it shouldn't be able later to go back on that deliberate choice. But without worrying about this, after the Supreme Court decision, Zurich Insurance released a press statement, apparently with a straight face, where they said that they'd been unflinching in their pursuit of fraudulent claims, which seems somewhat ironic and seems to be a misrepresentation of their own position. Because given that the trial judge found that Zurich knew that the claim was fraudulent from the outset and settled anyway, settling seems to me to be a long way from the unflinching pursuit of fraudulent claims. But I think one reason for a degree of confusion in the Supreme Court decision in Zurich is that it blurs the distinction between claims in the tort of deceit, claims for damages in the tort of deceit, and claims to rescind a contract for misrepresentation. And both Lord Toulson and Lord Clark relied heavily on claims for damages in deceit, which were just not relevant to the claim in Zurich. And it's a shame that the two were elided, because I think the bases for the two claims are distinct. I think this can be seen from the older cases, that damages for deceit are based on the fact that the defendant was lying, and the claimant's belief in the lie was not a freestanding requirement of the claim. Whereas in claims for rescission on the grounds of misrepresentation, even fraudulent misrepresentation, the cases before Zurich were clear that the claimant must have made a mistake as a result of the misrepresentation. And I think that seems to me to be right, from a policy perspective too, that the effect of Zurich is that it undermines the finality and certainty of compromise agreements, and it makes it particularly difficult to settle claims of fraud conclusively. But it has been unsurprisingly welcomed by the insurance industry, who are very happy with the Supreme Court decision, because now insurers can settle quite quickly and with relative ease, because settling doesn't present much risk when you know that you might be able to rescind the contract if it later turns out that the counterparty is exaggerating its claims. So Zurich is a decided case that I find troublesome. But I'd now like to talk about two cases that are ongoing at the moment, and we'll have to see which way they fall. So first, I want to say something about duress. And there are two main ways that duress might be relevant in the context of bad bargains. So first, a party might try to escape a bad bargain by threatening to breach its contract, where that leaves the other party with no reasonable practical alternative but to succumb to the threat. And the courts have clamped down on that. But there, the threat to breach a contract is a threat to do something unlawful. It's a threat to do something that's unlawful. More tricky at the moment are situations where a claimant has made a bad bargain, but then claims that that contract is voidable for economic duress, where the threat made by the other side was not unlawful, so where the threat was lawful. And this involves lawful act duress. And this is an issue before the Court of Appeal at the moment in a case called Times Travel and Pakistan International Airlines. The appeal was heard at the end of November, and I think we're still waiting for judgment to be handed down. I did check this morning and couldn't find it. I was very worried it was going to be handed down at 10 o'clock this morning. But in any event, it seems to me the sort of case that could go up to the Supreme Court in any event. So in this case, the claimants were travel agents. So Times Travel and Nottingham Travel were travel agents, and their business focused on selling airline tickets to the British Pakistani community. And the defendant, Pakistan Airlines, is the flag carrier of Pakistan and offers the only direct flights between the UK and Pakistan. And the claimant sold the defendant's tickets. And then the defendant wanted to change the way it calculated the commission it would pay to its travel agents and demanded that the claimants sign new agreements. And as part of these new agreements, with this new commission rate, the claimants would have to give up their rights to commission that had already accrued. And in order to persuade the claimants to sign these new deals, the defendant said that if the claimants didn't sign, then they would no longer be able to sell the defendant's tickets at all. And this inevitably would have put the claimants out of business. But importantly, that threat is not in itself unlawful, that the defendant should be free to choose with whom it wants to contract. And that's an important aspect of freedom of contract, or freedom from contract. The defendant can choose who it wants to contract with. And because the claimants felt they didn't really have a choice, they signed these deals, they signed this new agreement, and at first instance, Mr. Justice Warren held that they'd been subject to illegitimate pressure and could rescind these contracts for duress, that the claimants had been successful and reliable agents for the defendants. They weren't given sufficient time to adjust to losing their ability to sell the defendant's tickets, and so they had no reasonable practical alternative but to take the offer. And we'll see what the Court of Appeal says, but that decision seems to me to be problematic as well, because the threat the defendants made was simply that they wouldn't allocate tickets to the claimant in the future. And that's not a wrongful act. And again, the decision of Mr. Justice Warren might undermine the finality of settlement agreements in a similar way to Hayward and Zurich, and allow claimants to escape bad bargains. Because it seems to me that a party should be able to threaten not to renew a contract or not to enter into a contract without this being illegitimate pressure for the purposes of duress. And that's especially important between commercial actors who operate on the basis that they are entitled to act in a self-interested manner. And each contracting party has a choice whether or not to contract on the final terms. You know, one party might drive a very hard bargain, and it may ultimately not be what the other party wanted. But then the other party has to make a choice whether to just walk away from the deal or whether to sign the contract anyway. And if the contract is then concluded, I think it shouldn't be set aside for duress. Now, on the facts of Times Travel itself, there was some unlawful conduct earlier in the story which might be relevant, which makes it a slightly harder case than how I presented it. But as a point of principle, I think it would be good if the Court of Appeal were to stamp down on lawful act duress as a general proposition. But I suspect that's unlikely. And I mean, the problems in this area stem from an earlier Court of Appeal decision, CTN, Cashin-Carry and Gallagher, where Lord Justice Staines said that he thought that introducing lawful act duress would cause undesirable uncertainty in commercial bargains but he refused to say never. He refused to say that this was impossible. He was a never say never sort of judge and always allowed this possibility. But the problem with that is that it generates uncertainty, and I think in this area it would be better to have a hard-edged rule and to stamp down on lawful act duress. But I imagine that decision will come out soon, and we'll see what the Court of Appeal says. And then the last last area that I want to mention involves frustration of contracts. And frustration is a very narrow doctrine. So where there's a supervening event, where there's something that happens after the parties have entered into the contract, one party might argue that a contract has been frustrated or automatically killed off, rather than accept that the contract is still subsisting and find itself lumbered with a bad bargain. But frustration only arises where there's a change of circumstances that makes performance a thing radically different from that which was undertaken by the contract. But it's also very clear that a party is not excused from performing his deal merely because that performance turns out to be unexpectedly difficult or expensive or burdensome. So it really is a very narrow doctrine indeed, but it's garnered a substantial amount of attention recently on the question of whether or not Brexit will frustrate contracts. And so this last case is a Brexit-related case. It's the case between the European Medicines Agency, the EMA, and Canary Wharf, which was heard by Mr. Justice Marcus Smith just last week. So this is real cutting-edge stuff, where the EMA signed a 25-year lease for a substantial property in London in 2011. And given the decision of the referendum to leave the EU in 2016, it decided to move its operations to Amsterdam. And it has just left its premises in Canary Wharf. And so it seeks to escape its contract with its landlord, Canary Wharf. And the case raises a number of issues, and I don't know all the facts, and we'll have to see what Mr. Justice Marcus Smith says, but I find it difficult to believe that the court will find this contract being frustrated on what I know so far. I'm not sure that there has been any radical change in the nature of the obligations owed, where the landlord can still provide a property, the tenant can still pay rent. I understand this means that leases will virtually never be frustrated, but that also seems right to me. But in any event, here this is a case where you can have sympathy for the EMA, but basically the tenant just doesn't want to be bound by this contract anymore. I think this is another example where the EMA finds itself stuck with a bad bargain. And if, as the press report suggests, if there is no break clause in this lease, and there's no other term of the contract, like a force majeure clause, that can be relied upon, then the court shouldn't subvert the contractual allocation of risk by allowing the EMA to walk away scot-free. That we just don't know what happened in the negotiations very well. It might be that the landlord reduced the amount of rent it asked for in return for such a long lease without a break clause. And each side, of course, would be aware that external events might happen that would make the contract a bad deal for one party or the other. So, although it might have been a basic assumption on the part of the EMA that the UK would remain part of the EU, it seems very unlikely that the landlord also made that basic assumption. And if the basic assumption isn't shared between both parties, then I don't think the contract should be frustrated. So again, we'll see what the judge says in that case. But it does seem unusual for there to be a long lease like that without any break clause. And its absence might suggest that the EMA could have a claim in negligence against its advisors. But that's not very popular with the lawyers in the room. Whether they could have a claim in negligence against the advisors. But I don't think it's up to the courts to add a break clause or to add any sort of term. And again, that's similar to the Hydro-Quebec case, that it's just not for the courts to add a term. So I'm looking at the clock and conscious of the time, and suspect I should really wrap things up now. I realise I haven't covered everything I'd say in the blurb for this lecture. That's because I was made to write a blurb for the lecture before I wrote the lecture. But the written paper does cover more grounds. But regardless of the area that we're considering, whether it's undue influence or unconscionable bargains or remedies, then I think generally a robust approach should be adopted, and the courts shouldn't help parties to escape bad bargains. So parties might have self-help remedies available to them. They might be able to terminate the contract for other reasons. But generally, the role of a court should just be to uphold the party's contract and not be swayed by sympathy for one party which finds itself stuck with a bad deal. And I think that it's helpful to think about the importance of bad bargains generally, because I think contract law comes into sharper focus when considering bad bargains. Because where a contract is good for both parties, then contract law has very little role to play. Where the agreement made between the parties is advantageous for both sides, neither side needs to rely upon the law of contract. But a bargain which is bad for one party leads that party to seek to improve its position in some way and to have resort to legal doctrine. But it's important to remember that a contract which is bad for one side will generally be good for the other. And so sympathy for the party on the wrong side of the bad bargain shouldn't distort the result of the case, and it shouldn't deprive the other party from the fruits of a good deal, especially in the commercial context. So I won't say anything more about bad bargains. Thank you for listening to that. I've sort of realised when Pete was saying that he said that the purpose of an inaugural lecture was to give an overview of a person's research and their research programme. And I'm not sure that I've really done that. So it turns out I didn't understand the purpose of this inaugural lecture as well as I should have done. But I think in any event, I'd have found that difficult to do, that I'm guilty of dabbling in a lot of different areas, which would be hard to tie up into a single theme. But I am primarily interested in legal doctrine. I'm primarily interested in what the cases say and how we can explain them, and how we best explain how the law fits together. And I'm very fortunate to be at UCL, which is a faculty where doctrinal work is valued and encouraged, where in academia generally it's falling a little bit out of fashion. Big theories are much more in fashion. And there's a good line from the Chief Justice of the US Supreme Court, John Roberts, where he noticed this trend of doctrinal work falling out of fashion. And he said, you can take the nearest law review and open it to the front page, and it's likely to be something like, Immanuel Kant's influence on the evidentiary rules of Bulgaria in the 18th century. That what academics were doing is rather esoteric and niche. And there are clearly lots of different approaches to legal research which are very valuable and which should be encouraged. But it's not the sort of work that I do. What we've done in this lecture, what I've said in this lecture, is more like the sort of work that I do. And as Professor of Commercial Law in London, I think it's important that my work engages with what the courts are doing. And to that end, I'm very pleased to see a number of judges, practitioners, students, academics and former students who've come tonight. As I said at the start, it's a real privilege to be here. So thank you very much.
Well, I think it falls to me to wrap up at the end of what was both an entertaining and, in many ways, timely lecture. Contract law lies at the heart of our economic life, and Paul's lecture was a timely reminder that we depart from the rules of contract law at some peril. Paul referred to the Chief Justice of the US Supreme Court. I have to say that until I heard Paul's lecture, I hadn't appreciated the resemblance between Paul and another US Supreme Court Justice recently departed, Antonin Scalia, who wrote an article a long time ago, The Rule of Law as the Rule of Rules, emphasising very much the same message, that we depart from clear rule-like forms of doctrinal law at some considerable cost, which it's very easy to lose sight of. Could you join me again in thanking Paul for his entertaining and very interesting lecture?
And I'm afraid that inaugural lectures deans do have the last word, because I now, on behalf of the Faculty of Law, formally inaugurate you, Paul Davies, as Professor of Commercial Law at the Faculty of Law of University College London. Congratulations.
Thank you. Thank you very much.
In fact, it was all dreamed of, not 18 months later.
And thank you all very, very much for coming. And I think there are some drinks waiting for us outside. And wish you a very pleasant evening. Thank you again, Lord Secretary. It's a pleasure.